For the third day running, the Supreme Court of the land has sat as part of proceedings for the 2020 presidential election petition. Now, the day prior, that is the 19th of January, the Supreme Court dismissed the application by the petitioner of this particular case, John Dramani Mahama, led by his counsel, Chachichi Kata, to serve some interrogatories on the first respondent, the EC, to answer some questions which they believe will narrow down the issues to be determined by the court. Now, following the dismissal, members or the parties to this case, that is the petitioner, first respondent and second respondent, were asked to file their memorandum of issues, that is on today, January 20th. Now, before they did that, it happened that the lead counsel of the petitioner filed for a review of the ruling, as well as for some documents to be produced by the first respondents. That is more or less the pink sheets, the original pink sheets that were used by or received by the first respondent as part of the 2020 presidential election. Now, following the submission of the memorandum of issues, which were issues that the parties were hoping to be determined by the Supreme Court, the Honorable Court decided or narrowed down all these issues to 5 and have decided that these 5 issues will be up for determination as part of the 2020 presidential election petition. Now, a time now for us to actually head into the chamber proper for what transpired on the 20th of January.
The court resumed sitting to an empty seat at the bar on the petitioner's side.
Mr. Sedukatia, please, may you have my attention? May I have your attention? Please, where is your counsel?
Where is your counsel?
At the registry. Yes, please announce yourself.
At the same time, lawyers for the petitioner were at the Supreme Court registry filing more processes.
My lords, I apologize for being late. My learned junior is also on his way. We were trying to ensure that we complied with your orders yesterday. We have just succeeded in filing a memorandum of issues. We are also in the process of filing an application for review of your ruling yesterday.
Given that former President John Dramani Mahama's lawyers had just filed their memorandum of issues, the court retired.
Mr. Chikata.
Yes, my lord.
Yes, we want to have copies and consider it, so we will rise and come back.
Very well.
For the issues.
That is correct.
Yes, okay.
All right.
What would follow thereafter would be dramatic and engaging.
We accordingly set down the following issues for the determination of this petition. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techie-Mansard constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020.
Then the president of the court added modalities for conducting the petition.
By virtue of the powers vested in this court under Rule 5, Sub-Rule 4 of CR 99 to dispose of this petition within strict timelines, the following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021.
But Mr. Chachuchi Kata, lead counsel for the petitioner, was obviously dissatisfied.
I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's a 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
A senior member of the bar, Dr. Dominic Ayeni, got on the wrong side of the bench.
Mr. Ayeni, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair.
But Dr. Ayeni is sorry. For now, the court stands adjourned till Tuesday, January 26, 2021, when it will begin hearing the substance of the election petition. In between the time, however, the petitioner is expected to file his witness statements and affidavits by close of business on Thursday, with the accompanying responses expected to be filed by the first and second respondents by close of Friday. Meanwhile, the court is also expected to be reconstituted on 28th January to hear the application for review filed by the petitioner earlier on Wednesday.
So about 2 hours or so of activity in the chamber of the Supreme Court. The Honorable Court of the Land adjourned sitting to the 26th of January for its fourth sitting. But before it adjourned sitting, it essentially gave out some orders to all relevant parties to actually comply with. Now, the lawyers have left the chamber or joined the media to essentially give out their thought about the orders given by the Supreme Court. Let's first hear from Frank Davis, followed by Marietta Brewer Pong, former Attorney General, who is a member of the legal team for the petitioner.
It is instructive to let you all know that the three issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable cause of action. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you, they were advocating for a live broadcast of the proceedings. We were not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint or the other.
What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Yeah. Now, that means we have just 1 day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years, and we know what the rules are. And every objection that we've raised is grounded in law and is justified. Now, interrogatories, as is stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice. Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Currently here with Eduji Tamaklo, a member of the legal team that just spoke. So the issues of time, issues of expedition have come up once again.
All that we seek with respect is that at the end of the day, everyone will walk from the throne of justice, believing that justice, in fact, has been done. If I leave with a view that what happened was expedition and not justice, we should always remember that election petition is about the mandate of the people. It's about the mandate of the people. If you rush it, what will be the consequence? In the last petition, all these preliminary matters were taken before witness statements were filed. Because if you allow these processes, these interlocutory processes to conclude, in any case, the rule that they are referring to gave 5 days for the pre-trial conference. Today is day 2. So in terms of even speed, have we delayed? Today is day 3. For pre-trial, today is day 2. So far in this whole election petition, this is the 3rd day. So where is the delay? How can anybody accuse anybody of delay? What has been the delay?
Yes, so much. Eduji Tamaklo there, and Dr. Ayini there. Senior, there was some developments in court with regards to your conduct. Can you speak us through that, and then also the request by the court for you to, should I say, comport yourself? Can you walk us through what happened? What were you trying to prove?
Well, I wasn't trying to prove anything. I was just naturally shocked at what was happening. You know, the fact that the CJ came out, or the panel of judges came, and without consultation with the parties, as mandated by the rules and practices and conventions relating to case management, went straight ahead to announce very tight deadlines, you know, basically allocating less than 10 days for this petition to be determined by the court. You know, I was very, very, very shocked. And that is how come that, I mean, it was a natural reaction. And I think the Chief Justice, you know, I caught the eye of the Chief Justice, and that is how come that he admonished me, and I duly apologized. But I was very shocked that they were I mean, you know, basically imposing, you know, timelines and pushing those timelines down the throat of the parties. And, you know, when lead counsel for the petitioner was on his feet, you know, I thought that they would have taken account of some of the submissions he was making. He was saying that there are pending preliminary issues, okay, such as our application for review, which will have an impact if, for instance, they fairly consider the application for review. That application, if granted, will have an impact because then the interrogatories will be served, right, on the other parties, and they would have to spend some time answering those questions and filing them in court. So how do you, I mean, in the face of the pendency of the application for review, or I say that we are starting a trial on the 26th of this month.
They were the ones trying to create the impression that the mere fact that they have filed an application for review must operate as a stay on proceedings. And the court explained that the mere fact that you have filed one does not mean that the court will stay proceedings. The court will continue but still hear you. So this misinterpretation should stop. Bear in mind that at every point in time, when the substantive matter should be heard, our friends on the other side are quick to bring in an interlocutory matter aimed at further delaying the process. They did it the first time, the court granted it to them. The second time, the court did not agree with them. Today, they brought in an application and are interpreting it that application must operate as a stay. And the court has been clear, it will hear them, but it won't operate as a stay. Now, the court is saying that we should file witness statements. Why? Because you filed a petition and attached to it a list of witnesses that you had in mind. Mr. Mahama filed this petition on the 30th of December. It's almost what? Is it 21 days now? Yeah, 21 days. That means that he knows his witnesses and he knows the testimony they are going to give to buttress his pleadings or to buttress the government of his case. How is it that 21 days after the fact, when you are asked to file whatever they are going to say, you say it's too early? It's ridiculous.
I mean, consistently they have raised the point that the 42 days essentially will not, be enough in terms of...
It's not true. We were all in Parliament when we passed the law. Their representatives were in Parliament when we passed the law setting out the timelines. It's not the court that has decided it's 42 days. We passed it in Parliament. Why? Because all of us sat in Parliament and said expedition must be brought to this matter, but justice must not be sacrificed.
Justice delayed, justice denied.
It is also part of it. Justice must not be sacrificed. So if you chose your witnesses on the 30th of December, and on the 20th of January, you are being asked to get ready to bring their statements, how can you say that it is too early? Are you saying you didn't know what they were going to say, your own witnesses, or you didn't have a draft of the issues? Or are you saying that you are hoping, or you were hoping to use the interrogatories to find issues to bring? Then that would be a fishing expedition, which the law is against.
Can I give you their response? What they are saying is that there are issues pending, and which they are allowed to, bring before the court within the 5 days given to them.
Issues such as what?
Issues such as the fact that they are asking for a review of the ruling.
Review is going to be heard tomorrow.
And as well as
just that the process doesn't have to stop while you're asking for the review.
But do they have the 5 days then?
They have a period within which they can file all their issues and get the court to hear them. Yesterday, the court said that they are being flexible despite the timelines. In fact, the court has already exceeded some of its timelines. Okay, so they are being flexible. They are hearing them. This attempt to drum up to the public that somebody is stampeding them is not true. They are the ones who are consistently seeking to stop the process from going on.